Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to Just Verdicts. I'm your host, Brendan Lupetin, and today I'm super psyched to be joined by attorney Helen Lawless from Klein Inspector, who's here to talk about a great and really interesting verdict that she and David Incho from her firm recently got, and that I read about in Legal Intelligencer. And so I immediately emailed Helen and said, hey, will you come on the podcast and talk about this really cool verdict? And Helen was kind enough to do so. So Helen, thanks so much for joining us today.
Thank you for having me.
So reading about you, you were not only what it sounds like, and I know that we all have to create our bios and so forth, but you've got a really impressive background of debate, both in Europe and in the United States prior to embarking on your legal career. And I'm curious, number one, how did you get into that? And number two, for up and coming trial lawyers or people aspiring to maybe one day become trial lawyers, do you think that was a good foundation for you as sort of a jumping off spot to get into the work that you do now?
I think it was a fantastic foundation, and it was one of the things that drew me to law in the first place. It's one of the reasons that I applied. So the kind of debate that I did is potentially not the one that you may be sort of thinking of. I did what's called British parliamentary debate, which is actually the world style. There are many US former lawyers, like senators, who have done this, and it is entirely extemporaneous. So you get a topic, and then you have to talk about it 15 minutes later, which is incredible because it means that you have to essentially think on the fly. You can't do any research. You can't use any outside sources. It's just logically thinking through the issues, and you do it with a partner. So in terms of thinking on your feet and in terms of teamwork, which I think are two incredibly important lawyer skills and trial skills in particular, I think it was a fantastic foundation, and many of the best oral advocates in my class and many of the best lawyers that I know now are people I knew from debate.
Really?
Yes, it's a really impressive cohort.
Yeah, I mean, just describing that, and you're right, I did not realize it was that type or style of debate. It sounds very intimidating, but I could see how it would really build some important muscles for trial work. Can you just give me an example? Because that's fascinating. So you are in this competition and they just tell you the topic, and then you have essentially 15 minutes to gather your thoughts on what are going to be your main argument points and so forth. And then they hit the buzzer and you're off to the races?
Yeah, so you have 15 minutes with your partner. You go off, you have a discussion by yourself. You're also given a side. So you have to also have a lot of dexterity, politically and mentally, because you don't get to pick what side of an issue you're on. This is your position, much like this is your client, go forth. And you also, because there's two teams on each side, if you are the latter team, you have to say something new. You have to extend the argument. So depending on where you are, you have to be quite tactical about it and what you say versus what your partner. And you also have to take questions on the fly. So the other side will interrupt you and say, hey, I have essentially an objection, which you then have to respond to, right? So I think all of that was incredibly foundational for me. I really enjoyed it. I got to compete all over the world. It was a great way to meet people. But I noticed even when I got to Stanford for law school that many former BP debaters were in my class, and they were the people I was most worried about during moot court and competitions like that.
Were there a lot of Americans that had done it also?
Yes. When I applied to law school, Harvard were the reigning world champions at the time.
Oh, wow. Okay. Simpleton me had never heard of this, but it's really interesting. How did you get drawn into it to begin with? When did you start? Middle school or the equivalent?
Late high school. I wasn't really sure about it at that time. And then I went to UCD, University College Dublin, for undergrad. And I saw this girl she is now a barrister. She was blonde, she was cool, she was older than me, and she was just so fierce and so smart, and I wanted to be her. So I got into it, started doing pretty well off the bat, really enjoyed it, really enjoyed the people I met with. And I ended up training people towards the end on how to do it and just took a huge amount from it. So I would say that and my uncle, who is also a lawyer, probably the two biggest inspirations for my applying to law school.
It was your uncle's last name Lawless as well?
No, he has Smith, which is
Oh, okay.
far more innocuous.
Because I was thinking, was it like one of those things where lots of people named dentists become dentists and you're Lawless and it's this natural, obviously, uh, pre-existing conclusion that you're going to become a lawyer, but not
Nominal
necessarily.
determinism, right? Yeah.
Yeah. It is a great name to be a lawyer. I'm jealous. Lupetin is so generic, but Helen Lawless. I mean, come on. That's you've got to be a great trial lawyer. So, are you from Ireland originally?
My dad is, and I went to
Okay,
undergrad there.
gotcha. And then you mentioned you wind up, making the jump to Stanford Law School. At that time, did you think that you wanted to be a trial lawyer like what you do now, or was it, kind of a variety of potential avenues you were thinking of going into?
So when I went in, yes, because I knew I wanted to be in court and I wanted to do oral advocacy for a living. While I was there, I will say, I think some schools are better at orienting people towards trial, and Stanford was more appellate oriented and sort of corporate defense oriented. So I flirted with that for a minute, didn't really vibe with me, and went back to what I stood to do. I didn't return to my 2L defense firm, decided to not do that afterwards. And I went to the DA's office, which was really fantastic training and a great way to move to the city of Philadelphia as well.
I was going to say, so what brought you across the country from, West Coast to East Coast? I mean, if you can share that with me.
Oh, sure. My family had relocated to the East Coast, to DC. That's why I applied to law school in part here, as opposed to becoming a barrister. So I was looking to move back. I was looking to go to a city with a big DA's office. I applied to a few of them, and I just liked Philly. I visited, good gut instinct, really enjoyed it, and now I've been here for 6, 7 years.
Terrific. And how long did you work at the DA's office in Philly?
A couple of years, two and a bit. And then I was looking to make a move, and I had a really fantastic conversation with Mr. Spector, and I've been at KNS for 3 years now, and I'm loving it.
Didn't or does Shannon still teach a class at Stanford?
Yes, I'm ashamed to say that I didn't take it, but I
Okay.
heard from many of my friends that it was excellent, and I asked them during that process.
Because I was trying to figure out what would have brought you from West Coast to East Coast. And I was thinking, oh, maybe you took that trial class and you were a superstar and were, recruited to come out to the East Coast, but different reasons, but wound up in the same place. So did you get to try a lot of cases in the DA or at least, assist with them in that period of time?
I got to try a lot of waivers and do a lot of motions practice, but I was there a fair amount of my time overlapped with the pandemic, and there was a lot of factors and a lot of incentives in places to not have juries. They were really trying to, for a safety perspective, not have them. So a lot of waiver trials instead.
Awesome. So then, wind up at the, super firm of Klein Inspector. And now I'm sure getting to work on a lot of interesting cases, which, brings us up to speed to the case that we're here to talk about today. And I'm probably going to butcher the one defendant's name, but it's Gerald Tritt and his wife versus Louis Wykai Lamb and Workcompvidence, PIA LLC, which I have to say, they could have come up with a better name for work confidence, right?
So it actually has a reason behind it, which is work and then evidence. Namely, they are trying to gather evidence, right, for workers' comp cases, but it does not roll off the tongue easily at all.
No, it's terrible. And I was thinking to myself, if I, having to say that over and over, an opening statement, that are people just constantly stumbling over the work confidence, and trying to enunciate it correctly. But In any case, yeah, I don't know about that name, but so tell us about this case. So this is not your typical run-of-the-mill medical negligence case. It's got a whole different vibe going on, and it's quite interesting because I've never heard of this before. But I could see how you have a good villain in this case. So tell us a little bit about what happened to poor Mr. Tritt due to work competence.
Yeah, so as you say, in most medical malpractice cases, it really comes down to deviations from the standard of care, right? Some doctor didn't do what they were supposed to do, and causation, right? Did that deviation cause a harm? And then maybe to some lesser extent, damages. This was really interesting because the central question that was looming over everything was, did Dr. Lamb owe Mr. Tritt a duty? Was he his doctor? That was the central question. So Dr. Lamb runs a consultancy service for employers. Employers hire this consultancy in order to do a myriad of things, but primarily lower the workers' comp costs for their employees' injuries. And they dress it up in various ways, but that is the point. And particularly companies that pay their own workers' comp costs, right? Companies that don't have insurance, but who are self-insured in that regard, which is a lot of construction companies. So our client, Mr. Tritt, is working at a construction site. He gets an injury. His employer immediately tells him, his supervisor tells him, you have to call the care line. Very innocuous name, right? He calls the care line and he speaks to those employees who are all nurses. It was a requirement that they be nurses. And they basically told him what to do with his foot ulcer for a period of 2.5 months. They text him all the time. They call him every day or every other day. They ask for photos of his foot. They ask him for symptoms. Has this changed? They keep telling him that the things he should be worried about are things like fever and systemic symptoms that could look like infection. And all the while, he's thinking that he's getting healthcare. He's thinking that he's speaking to a doctor. He's speaking to nurses who work for that doctor. Every time they identify themselves as being from Dr. Lamb's Workcompvidence, that's how they introduce themselves in all of the messages. And they are not telling him to do anything different aside from basically first aid. What Mr. Tritt doesn't know is the whole reason for that is if an injury is only treated with first aid, then per OSHA, it is not a recordable case, and it does not lead to any workers' compensation costs for his employer. So that's why they were doing that, and they monitor him so closely through this strategy that they call tight management to basically make him not panic and not go to a real doctor. They actually had that in their strategy guides. It said, we want to reduce panic factors on behalf of the injured person and their family. That was the point. So he thinks everything is fine. He then stops working at that construction site. The job ends. It's not that he's terminated, it's just the job ends. And then a couple of months later, he does develop those systemic infection symptoms that he was warned about. He immediately goes to the ER, and they tell him by that point that his foot is not salvageable and he needs a TMA.
So TMA being an amputation.
Transmetatarsal amputation, yes.
So this poor guy loses what? A whole bunch of his toes, basically, right? And part
All
of his foot.
All his toes and midway up his foot.
So what does that translate for him now as far as, is that a prosthetic situation or is he able to walk on that partial foot? What's the impact for this poor guy?
He can only walk with assistance. So he requires either a scooter or a cane or some sort of assistance. He's currently in treatment for other ulcers. So he's currently on a scooter. Our hope is that he will get a prosthesis eventually, but he hasn't qualified as yet. But he will need assistance walking in some manner for the rest of his life. He is permanently disabled and unable to work, which is obviously devastating for anyone. It was particularly devastating for our client. He's a kind of old-fashioned, hardworking guy. And the fact that he couldn't support his wife and was, at home was really mentally tolling for him. So all of those issues, balance is a particular issue. and he's going to need, ongoing medical care for the rest of his life.
So, Helen, I'm curious about, a case like this. The a lot of the cases we discussed, I'm not all that interested in the intake process because it's somewhat self-evident why you would take the case. Case like this, guy calls you worker. Yes, it is an amputation case. However, on its face, it's the result of essentially a diabetic ulcer. And those cases historically within the medical negligence world are notoriously difficult because a variety of just the issues that are present with somebody that has uncontrolled diabetes that led to that wound in the first place. So my question is, what was it about this case that clued, yourself or whomever the intake person was, if to think kind of like a little step further, that this isn't just a, diabetic wound case, and maybe there's this bigger kind of systemic issue that is what this is really about, that makes the case a lot more interesting to dig into?
So full disclosure that I was not working on the case when it was brought on.
I was wondering about that, but yeah, but please go on.
But I think if it weren't for the bad guy, as you put it, it would have been less interesting, right? The aspect of this that is really needed addressing is the nature of this business model. And until quite recently, they were advertising it. It was on their website. They've changed that since. But at the time, you could just look up what these guys did and see that the whole point was to dissuade workers from getting healthcare. And I think that was really something that drew K&S to taking on the case.
And that was, how long had this operation, so to speak, been going on? I mean, I can see totally why, the market, the appeal to, whether it's the employers or the comp carriers, why they would be interested in a service like this. But how long had it been going on? And I mean, you can only imagine how many other poor employees were impacted by this. But before, this case, were there other cases like this, or was this kind of one of the first ones of its kind?
So I think the business model morphed. Initially, it was a clinic that the doctor ran for occupational medicine, and he was essentially the kind of hired gun that you see a lot in the workers' comp space, right? Doctors who do inspections and treatment with the aim of disproving work causation, but in a sort of more standard way. And then he sees that and he decides to develop this other sort of sister company that does this other consulting model. And I think it was really based on, it's just me sort of reading between the lines here, but him seeing that, if you control the case from the beginning, and that's a factor that Sam Pond, for example, talks about a lot, right? If you can control the workers, what they interact with, who they interact with, what care they get from the outset, then you can control the care and you can control the case.
And so that became the business model. It's now going on. Probably there were other casualties of this, but certainly Mr. Tritt paid the price for it. So, walk me through how, to the extent that you're familiar with it, how the discovery was worked up to dig into, the business nature that led to what was really a misrepresentation, and then also the steps that had to be taken to prove that doctor-patient relationship, which was one of the hot issues in the case.
So on the latter, it's really about analogizing to, and how a telemedicine service would operate, right? And I actually think in a weird way, COVID probably helped this case because people became more familiar with telemedicine, but it was really asking questions in one of those depositions that are oriented towards, well, this is exactly what you would do if you were seeing or treating someone medically, right? You'd ask them their medical history. You'd ask them about their allergies. You'd ask them about the medications they take. And also proving the amount of knowledge on the provider's end, right? These were not call center workers. These were nurses. They knew exactly what to ask and what to say because they had medical backgrounds. And this put them in a sort of strange position while defending the case of being like Schrodinger's nurse. Like, I am a nurse, but I'm not being a nurse right now. I'm not your nurse, but I am. And that's how I can do my job. And that was sort of a strange line for them to have to walk during discovery. The documents, while some of them were very, very helpful internally, we also got a lot of things just, as I say, from their website, from looking at public sources. When you ask in a deposition, have you ever been sued before or have you ever been deposed before? Go find that case where they were deposed before or they were sued before, because even if it's not admissible, which, it may or may not be, depending on the trial, just looking at how similar previous situations have been very, very useful. So it was all with the minds to develop, this is a sham practice, right? This exists in order to emulate something so that you will not go somewhere else.
I assume you had to deal with the summary judgment motion, given this particular issue. That there was no, and it's sort of funny because you read a lot about medical negligence cases. You read like books on the subject, and the books will start with that. What are the steps of it? And the first step is well, there has to be a doctor-patient relationship. And, you're usually like, duh. I mean, of course, that's why we're, let's skip that step. Let's get to the negligence part. But meanwhile, it's a prerequisite for you to have a claim. So there was a summary judgment argument on this, I'm assuming, right?
Yes. I wrote a pretty extensive response to this that was almost exclusively on this issue. And we really needed to work up that argument. What was interesting is most of their cases were analogizing to basically DMEs, like one-off medical examinations of patients. But this is not that, right? This is so many more interactions, dozens of texts and calls over months and months. But it also doesn't look potentially 100% like your typical doctor relationship. So we had to sort of walk that line in between. And I think the MSJ it was important for us to get over that hurdle because, as you say, duty is not something we always think about, but it also totally defines your field of play, right? The duty defines what they are supposed to do or not do. It is the onus on them. So if you can frame duty in a way that works for you, that's very, very helpful.
Did you have to deal with the issue again at trial? I mean, so you survived summary judgment and, presumably, there's a factual question as to whether there did exist a duty by the doctor or his practice to your client. Was that then again, though, revisited at trial as a question that the jury had to consider and answer?
So we filed a motion asking that not be the case and
Yeah.
that we not address this issue because duty is a legal issue. The judge denied that motion. She said that it was a factual question that the jury needed to consider. There wasn't a specific question on the verdict sheet. I think that could have run us into some trouble. But the first question is, was he negligent? Our assumption being that builds that question in. And it was very clear that was defendant's position from their expert testimony, from their closing argument. No one was hiding the ball about what the question was. We just needed to couch it in factual terms because of the judge's ruling. And yes, that was the case they made throughout, that he owed him no obligation whatsoever. And defining what the obligation is, I think that's a really important thing to stress if you're ever in these kinds of cases. What is it they should have done? And what we were saying they should have done, namely referred him to another physician, is a very low bar, right? It's a very low ask. So the idea they had to put forward was that they didn't owe him anything. That's a strong position to take.
I was going to say, so while the judge said it had to be addressed because it was a factual issue, it wasn't its own independent question. It was just there was the standard question of was Dr. Lai and or his practice negligent, and that sort of included there being a duty, right? Is that fairly accurate?
It has to, right? It
Right.
has to.
But interestingly, it probably helped you because the defense was sort of emboldened to make this argument that, we don't owe this guy any duty. And I could see it coming off quite sort of callous in the course of trial, like, well, we can treat this guy like crap because, and we did, basically it's almost an implication like, yeah, the reason why our care was so bad is because we didn't know him any duty. That seems like that could be a real problem for them if they, and it sounds like they did kind of forward that was a primary defense.
Yes, they had some secondary arguments around causation, and
Sure.
obviously there was the contributory negligence aspect, but a lot of their eggs were in the we didn't owe him anything basket.
Okay. So before we get into why the case tried and start to get into the trial specifics, what I mean, in a nutshell, what was the comparative claim, or why was he at fault? That notwithstanding what they were telling him, he still should have gone out and gotten his own independent medical care.
Yes, so that he should have gone, he should have sought care. I think the period of time that was very difficult for us was the period after he had left the job site, but before he went to the ER. One could say that even if he had been following their directions beforehand, they were now not in touch with him. Why didn't he seek care independently at that time? He did reach out to them more than once to try and see what he should do. And he continued to follow the advice that they had given him before, but he didn't hear back. So I think that was a difficult fact for us to get around. And then just this broader argument of, well, he's got diabetes. People who are overweight and people who at some points are non-compliant, basically deserve what happens to them, was the thesis of that argument, which I found less persuasive. I think one thing that's really important when you're in a case like this with one of these, kind of chronic conditions is to really stress how high the bar is for compliance. Medical providers use this term, so and so is not compliant, in medical records all the time. But it really means that you just haven't done one thing that you were supposed to. Like if you've ever been on a medication for, blood pressure, birth control, anything like that, then you've probably been non-compliant at some point or another. And just stressing to the jury that this isn't as big a word as you think it is actually it's very helpful. And we did that through multiple ones for our experts, just to say, that doesn't mean so-and-so is a bad person who's trying to, go against their doctors at every turn. It just means that you maybe failed to adhere at one point or another. And our client didn't have health insurance for large portions of time, right? He worked individual jobs for slates of time. He did not have a full-time 24/7 employer who gave him health insurance.
How big of a gap was there between him ending that employment that had him being involved with Workcompvidence and, when he actually finally got diagnosed with what sounds like osteomyelitis from diabetic foot infection?
Yes, he leaves in the middle of August and then suffers the amputation in November.
Okay, so 3 months-ish in that realm, and you said that he did try to call them back a couple times, but they basically ghosted him at that point?
Yes, so they had closed his case, which obviously he did not know, which was another thing that we could use in our quiver, essentially, is like, you could have told him. You could have just said, we're not going to do this anymore.
Yeah, that is, poor guy. I get just getting kinda left out in the cold, and then they turn around, and they blame him, as they always do. So, why did the case have to be tried? I mean, obviously, I could see the defense putting all their eggs in the basket of summary judgment when that goes down in flames and they're going to trial now. Was it just because they still felt that sometimes it seems like they just get in their mind, like, no, we're not at fault. We have no duty. So we have to defend this case. Or was it basically all the factors you've been telling me so far?
Yeah, so there was no opinion because many of the cases in Philadelphia that go to summary
Just a
judgment,
straight
right?
denial.
Yeah. So I think if there had been an opinion or we had been elsewhere, then maybe the MSJ would have been more dispositive. But they really had it in their head that they had a 100% defense. It was a try case. We were told that repeatedly. There was no offer. So I'm sure you've heard from many great trial lawyers, some cases just have to be tried.
Those are my favorite ones when there's no offer, because then yeah, we can only go up from here. So no offer. And so talk to me about how you all prepared for the case. I mean, did you have a theme? what was your approach to, say, opening, or your frame of the case that, you got initially out in front of the jury first?
Yes. So Dave's opening was really around, this is a strategy. This is a strategy that is thought through, that they have composed, and it worked. It did exactly what it was supposed to do. And going through the aspects of their website, their brochures, all of the ways in which they appeal to employers to say, hey, we're going to reduce the amount of time that your workers are out of work. We're going to send them either to our clinics or to no clinic at all. We're going to reduce your recordable cases. It was all around, this is exactly how we're going to benefit you. And compare that with exactly what happened to Mr. Schritt. He fell for it hook, line, and sinker. It worked, and did, from his employer's perspective, exactly what it was intended to. So that was really the theme throughout the case was, okay, so what did you want to happen? And they were painting this consultancy essentially as a referral service. Employees call us and we send them somewhere else. It was a very expensive referral service. If that was all you were doing, essentially acting like Google Maps for urgent care, then it was surprisingly high billing, right? And for us to say there must be something more to this, that had to be the constant refrain. There's got to be a reason that they're doing what they're doing, and why the employer is paying them so much to do what they're doing. Oh yeah, it's this thing that happened to our client.
In the opening, did your group use a rule of any kind, or like or like how did the opening begin? And I always ask these questions just because it's like different things I'm currently interested in. I'm currently working on new ways to kind of get into the start of my opening statement. So I'm curious, was it like, this is a case about, or launch right into a story, or was there a rule? If you can remember.
Actually, it was much like the beginning of our discussion of the case today. It was about the name. It was about the name and the two composite parts of the name, work and evidence. What does that mean? So we initially had a workers' compensation expert. He was excluded. Obviously, we didn't agree with that decision, but we had to move forward. So a lot of the purpose of the opening was explaining sort of basics of the workers' compensation system and the incentives within it. So that starting point of, this is why this is actually called this. It's about developing evidence to use against injured workers. That was the starting point.
Okay, very cool. And so you had a comp expert. So was the comp expert just out of curiosity, like a comp lawyer, or somebody that had handled comp claims? And I guess what ultimately was the basis for why they were stricken?
It was the comp lawyer. It was Sam Pond.
Ah, okay.
So he was stricken for, obviously we disagree with the decision, but some lines in the report that the judge felt could be essentially speaking on behalf of what Mr. Tripp would have thought, and essentially his perspective during interacting. Would he have viewed this as medical care? We argued that those were just a couple of lines in a broader report that was very useful for the jury in terms of educating them on a complex topic that not everyone understands. If you're not, familiar with it, you haven't gone through it. But she didn't see it that way. So we had to move forward with doing that, educating ourselves.
Gotcha. And so did the judge feel that, separate from the lines in controversy, that the remainder of the opinion of Attorney Pond was essentially like within the realm of a layperson could understand? People are generally, somewhat aware of what workers' compensation is. Was that the other half of it? Because I don't understand why the rest of the opinion would be excluded if it was educating people on something that they might not have a lot of knowledge about.
I would agree with you. I would infer what you said.
Okay. All right.
That's my
Gotcha.
assumption.
So sounds, my words, not yours, that maybe you were left scratching your heads a bit, but the show must go on as trial lawyers, right? So one of your experts gets stricken. So we got to go on. And sometimes that can actually be a benefit because it streamlines your case. So expert gets knocked out, opening statement. And did the plaintiff or did the defense opening, was it sort of what you predicted, that it was going to be largely, downplaying any relationship, that, this was essentially this, I would imagine they play it like, oh, this is this additional service that we provide our employees, and aren't we great for having this, but it's not medical care kind of thing.
Exactly.
Those are so predictable. So that was the thrust of the defense then, was just going that and plus causation, right?
Yes. They also had a theory that there was a different ulcer that had caused the necrosis and the infection, which just from the pictures alone defied common sense. But, that was their secondary argument.
Well, so that's interesting. So wait, walk that a little bit further. So he develops, I was reading in the statement, like an initial kind of blister under his foot on a certain part. And that's what he's calling about initially, because he knows he's diabetic and like, should I be concerned about that? And you said he was submitting photos, right?
Yes, photos over time that show that it's not healing, that show that it's getting worse.
So what was this? What was this other, the secondary wound argument? There was another one that showed up when they tried to say it was all that.
Yes, exactly. Even though you could literally see from the photographs, the black, all of the like physical signs of infection were very clearly tied to the first wound, and he'd had the first wound a lot earlier. Also, if you have a port of infection, it can then spread, obviously, and become diffuse. That was the word used throughout the medical records, was that this was a diffuse infection. But their argument was that another ulcer had been the cause.
Okay. So walk us through order of proof. How did you guys go about proving your case? Who did you call first? Your expert gets knocked out. And sort of how did you lay it out up until you closed your case?
So we still had a lot of expert witnesses. We had 3 doctor expert witnesses in addition to a life care planner and an economist. So we had all of them, and then Mr. Tritt himself, his wife, obviously, and one of his closest friends, who also happened to be a pastor and a former sheriff, which he was probably my favorite. So that was the lineup from our side. I think Mr. Tritt, our plaintiff, his testimony was even more important than it would be in many cases, because his reliance is obviously a central question, right? Why did he rely on their advice, and what would he have done if he hadn't? So that was really an important aspect of what we needed to get out of him. And then all of the other experts was really setting up what they could have done instead, what would have happened if he had been referred to a wound specialist, which is what should have happened instead. And wound specialist and wound care, as you know, is very expensive, it's very intensive, right? You have to go see and go to appointments all of the time, which also proved part of our motivation, because it shows exactly what they're trying to avoid. So that was our lineup of experts. I think in terms of proving, the motivations, once our expert had been stricken, the motivations of Workcompvidence, a lot of that came from the cross of Dr. Lamb.
Did Dr. Lamb ever personally interact with your client during that whole period of time when the claim was open, so to speak?
No, he reviewed our client's records, may have reviewed the photos. He denies doing it, but they were asked for expressly for his review. But the nurses repeatedly represented that they were calling from his office, that they were giving directions from Dr. Lamb, right? Dr. Lamb says do X. Dr. Lamb would like photos. Dr. Lamb would like to compare the photos. So from our perspective, it didn't really matter whether or not he was speaking with him directly. That was the representation that they were making.
Did you call Dr. Lamb or any of the nurses in your case in chief?
Yes, we called the nurse that he spoke with the most frequently, most routinely.
Yeah, but not Dr. Lamb, that you just called that nurse?
So originally the plan was to call Dr. Lamb. There was then an instruction that if we did that, there would be no redirect. So
okay.
that was an on the fly decision as well.
No redirect, meaning you mean so if they called him in their case, then you would not have a chance to cross him again, or
No, if we had called him as of cross,
yeah,
they would respond, and then
yeah.
we would not get one.
Oh, I get you. Oh, you couldn't come back after they had spoken. Okay, interesting. Was there a rationale for why that was going to be the case?
I assume judicial efficiency.
Okay, all right, fair enough. So then the idea was, well, we have to balance that versus, we can sort of counterpunch in their case if they call him to explain stuff, and that seemed the better of the two options, I'm assuming.
Yes, our thinking was it was too risky to let him, say whatever he wanted, say completely unforeseen things and not have a chance to respond. The nurse seemed like a more predictable witness in terms of what she was going to say. And so that was the strategic calculation made for those two witnesses.
Did you consider using any, whether it was video clips from his or any of the nurses' depositions, or reading any of their testimony in, or was it more, no, we're gonna deal with all these people live in trial?
We were originally intending to do a video clips from the deposition for one of the other nurses who was unavailable. But aside from that, no, I think really the best strategy, unless you have a compelling reason otherwise, is just have those clips and lines ready to go to impeach. But to the extent that you can get people live, it's always better, right?
Yeah, no, absolutely. If it goes that way, but I'm always like, well, what if they don't say what I want them to? Maybe we'll play the clip. We're always balancing all these different things. Was your client was not from Philadelphia, right?
No, he's very much from Alabama, as was his wife. One of the things that sort of joked on in closing was doesn't matter that people are different, good, hardworking people are from all kinds of places. And I think being true to who your client is, not trying to back away from it at all, but just helping the jury understand who they are and what matters to them. And that, he's a family guy just like you, just because sounds a little different as somebody who sounds a little different. And yeah, that was a really important aspect of the case, I think, was just embracing who he was, who his wife was. They were both very genuine. I think that really came across.
So did the pastor sheriff have to get zoomed in, or did he come up live for the trial as well? Or did you pre-record him, or
No, he came. He wanted to be with his
really?
best friend for moral support.
Now that says a lot when he's flying. I presume he's from Alabama as well, coming up to help his buddy out. That speaks volumes of the friendship. Um,
Absolutely.
in talking with lots of different trial lawyers on this podcast, I'm always interested to hear different. Everybody has different approaches to damages. And so, here you have a pretty evident injury and, an amputation. Part of his foot is, being surgically cut off. I know you had a life care plan. Did you have an economic loss plan as well?
Yes, we had an economist who spoke to his future lost earnings. And one thing that was kind of remarkable was obviously those statistics can be published to the
Yeah.
jury from both of those. Our jury did not take anything back. They had no questions in the entirety of their deliberation and came back with astonishingly specific numbers. They were really paying attention, which is amazing.
So meaning, so for example, a lot of times in the life care plans, the person that priced it out will give, say, yearly numbers, and sometimes those numbers will vary. I mean, a lot of times it's nice when they come up with kind of an average, but sometimes they'll vary. And so you're saying that they never even asked for, say, the economic reports or the life care plan reports. Were their numbers pretty spot on to what had been discussed, or were they like they came up with their own numbers like they sometimes do?
No, they used some of our very specific numbers. That's why we were impressed.
Very nice. And how did the economic in the verdict, how did the economic versus non-economic break out as far as the damages are concerned?
So it was a overall 4.42 million compensatory to Mr. Tripp, plus 100K in loss of consortium to his wife. of the damages to Mr. Tritt, it was 330,000 past lost earnings, 1.45 million future lost earnings. And then for the non-economic losses was 1.7. And then the future medical costs, which were those broken down because it's an MCARE case year by year.
Okay. And did the non-economic numbers, did they mirror or closely, were they similar to the economic numbers in any way? Like, meaning, because like a lot of times you're like, oh, they had this number and they just said, oh, well, we'll give them that same amount in non-economics. Or could you glean anything for the number that they gave for non-economics?
No, they used round numbers that I think they probably just came to as being reasonable. We had a very educated jury who were clearly paying a lot of attention, and some jurors who were familiar with care for amputees and had worked in that space before. So I think they were just going, I would assume, with their own reasoning, and they were round numbers that weren't really related to the economic damages.
Was there much dispute from the defense? Obviously, you had touched on that there was an argument on medical causation. Oh, maybe it was this other blister, or the always the implication that he was at fault for being diabetic in the first place, and then not being as careful as he should have been. But did the defense take issue or fight a lot over any of the, lost income or life care plan numbers?
We had about a day's worth of discussion about life expectancy. I really don't want to hear those two words for the foreseeable future. So yes, we had some discussion. It was a long day along what do these two tables mean? Which table should you use instead?
So this is the cross of your economist and on the basis of, and I priced it out over this number of years, basically.
And our physical medicine and rehabilitation expert and our life care planner.
So the life expectancy and making the implication that this guy's unhealthy, he's not going to live that long anyway. And so these numbers are trumped up to some extent.
Exactly.
So, and I'm curious about that because I was just talking recently with two attorneys in DC, Katie Bertram and oh my God, I'm having a senior moment. Kieran Murphy, sorry, Kieran, and they were just talking about they had a life care plan case and they dropped it. They had a big economic claim and they dropped it because they knew there was going to be this big battle from the other side. And I'm bringing that up. Did you guys weigh, well, we're going to be getting this life expectancy battle. Do we even want to get into it? Our poor guy's got a lost foot. Maybe they'll give him enough, but then you're balancing potentially waiving millions of dollars in economics. Did you do that calculus at all and lead up to this case?
I think there are cases where you have other forms of damages that are going to be so significant that that is worth the tactical decision. I don't think this was one of those cases, and I'm glad for it, based obviously in retrospect. But it was really important to emphasize what Mr. Tritt was going to need for the rest of his life. So my redirect of our PMNR expert, physical medicine and rehabilitation, which was after the first one of these, forays about life expectancy, was very short and to the point. But what I was really driving home for the jury was bigger statistics and more varied statistics, which is what the federal life expectancy tables are made up of, are better than small passed out statistics. And I could really tell that a fair number of the jurors, many of whom worked in science, data analytics, things like that, they got the point pretty quickly. So once we'd registered that, I felt better.
And how did you approach the testimony of your clients? I mean, obviously, in a lot of cases, our client's testimony from a liability perspective isn't so pivotal. Mr. Tritt's was in this case, but putting the duty and the negligence component aside, how did you approach the discussion of the impact that his injury had on him and his wife with their respective testimonies?
Absolutely. So I think one thing is to use use your supporting witnesses in a deliberate way that feeds into your client's testimony, right? So our client is this very, as I say, sort of old school guy. He's not someone who wants to feel sorry for himself. He's not someone who likes talking necessarily about his feelings or having a hard time. And I think what we did with his best friend and with his wife was to feed into that so that it was what the jury were almost primed for when he testified. And to have sort of concurrent themes that run through all of those witnesses, right? Like not being able to support his wife is really emotionally tolling for him, or this erodes his ability to do the activities that he really enjoys, but that were also pivotal to them as a family, like fishing and hunting were the ways that they bonded together and with their children, right? And just thinking about how each sort of character in your story can support each other, because then it's reinforced and then it feels more credible and your driving point home.
What did you think? You mentioned that his friend gave great testimony, but between the three of them, as you think back on the trial, to you, what struck you as the most kind of, poignant piece that came out that, kind of exemplified the damages in the case?
I mean, Mr. Tritt was incredible. He faced a pretty fiery cross exam and really held his own and pushed back only when very warranted, which was not a problem. I think sort of closing moment of his best friend was, "Are you worried about your friend?" He said yes. And then to have that before Mr. Tritt, who himself was talking about essentially his worry for his own future, I think that worked pretty well.
And then, tell me about, the approach to closing. Was it, tying up what had been addressed in opening, or were there new issues that had come about during the course of trial that you addressed? Was it, continuation of theme, or, sometimes people will bring out a new case frame according to like Mark Mandel and stuff. Like how did closing go?
I think you always want to be responsive whilst reminding the jury of why you're there in the first place, right? You need to respond to what has happened. You need to address it because otherwise you look like you're running away from things. But simultaneously, sort of bringing it back to this is why we all came here, right? This is what happened. And really the like baseline facts, because what defense are trying to do is muddy, you know, introduce all this extraneous information, introduce confounding reasons why something might have taken place. And it's really the onus is on you to remind the jury, hey, just as a big picture, this is why we're all here, right? And I think blending those two things is the way to go.
So tell me about the what was the ultimate verdict? And I know there was a little bit comparative. Like, how did that all shake out at the end of the day?
Yes. So our claim for punitives was struck. So it was all compensatory. And we had 39% contributory negligence attributed to Mr. Tripp, then 24% attributed to Dr. Lamb, and 37% attributed to work confidence.
Okay. So now what? Are you guys done with the case, or to the extent that you can comment on it, or are you appealing the punitives, or are there appeals pending at this point?
There are appeals pending, yes.
Good old appeals. I try to avoid those, but sometimes it's they're unavoidable. So what issues are I'm sure the defense is, has their predictable appeal issues. Are you taking up any issues yourself?
So defense appealed for a new trial on all issues and also in the alternative, lowering the award. We are currently, considering the response to that. So I don't want to comment too openly,
Sure.
but
Yeah.
obviously Client Spectre is blessed to have a fantastic appellate team.
I know. I wish I had one in house, and maybe we would be more bullish on appealing. But well, that's great though. Any other? I mean, as you look back on the case, any other, turning moments that you felt, kind of steered things in your direction? Sounds like your client was a likable guy that the jury was willing to get behind. I mean, did you think at the end of the day it came back to people were ticked off at this company and the purpose of it, or was it more, they liked your client, or a combination of the two?
I think a combination of the two. Our client seemed very credible, right? He just did not seem like an operator by any means, as compared to this actor that couldn't really give a straight answer to a question, that's sort of ducking and weaving. I think that comparison really worked for us and also supported the broader theme that, hey, this is a strategy and their strategy worked. It did exactly what it was supposed to. It was supposed to dissuade workers from getting healthcare at their expense.
Most excellent. Well put. Well, Helen, I think that wraps up a great summary of this trial. Mr. Tritt and his wife were lucky to have you and Attorney Inshow in their corner. I'm sure and hopeful that your appeal will hold up for his sake in particular. And this was really interesting. Thanks for sharing the story that I was so interested to read about. And I'm sure everybody in PA is going to be looking out for Workcompvidence cases now so they can continue the systems failure that you guys proved so well. So thank you for joining us, Helen. And Helen, we know you're a rising superstar at Client Inspector. If anybody wants to reach out to you, pick your brains about debate, trial, refer you a case, what's the best way for them to get a hold of you?
Thank you, Brendan. That's all very kind. The best way to reach me is by email, which is just my first name dot last name @clientinspector.com.
Awesome. Well, I predict I'll be interviewing you again in the future for some other great verdict. But in the meantime, congrats, and please extend my congrats to your co-counsel. That's awesome. And thanks for doing the show. We'll talk to you soon.
If you enjoy the show, please subscribe
Brendan.
to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.